For decades, Indian disability policy operated as a charity-based welfare model. State support was largely framed as a voluntary social service, subjective, inconsistent, and often dependent on available administrative resources. The 2016 Rights of Persons with Disabilities Act replaced that approach with defined mandates. Its preamble explicitly states the purpose, giving direct legal effect to the United Nations Convention on the Rights of Persons with Disabilities within Indian domestic law. India ratified that convention in 2007, agreeing to international principles regarding individual autonomy, equal opportunity, and non-discrimination. However, international conventions require precise domestic mandates to function. Abstract human rights are only effective when they are translated into specific, enforceable rules that institutions must follow. Previous legislative efforts frequently relied on vague language. Phrasing like best efforts or subject to economic capacity created administrative loopholes, allowing establishments to defer compliance indefinitely. The 2016 Act addresses these failures through a three-tier architecture. It defines exact medical thresholds, imposes strict institutional quotas, and establishes quasi-judicial enforcement powers. This framework is designed to move the concept of inclusion away from abstract policy and into a system of measurable obligations. To allocate resources and enforce civil rights, the state requires a rigid taxonomy to identify who qualifies for specific legal protections. This diagram illustrates the Act's schedule, sorting diagnoses into 5 statutory categories. But diagnosis alone isn't enough. Section 2R introduces the benchmark disability, defined as an individual certified to have at least 40% of a specified impairment. Under Section 57, this threshold must be legally confirmed by a designated certifying authority. It is a formal medical measurement used to determine eligibility for state support. The state uses this strict quantification to remove administrative ambiguity. A hard numerical baseline prevents local government officials from using their own discretion to decide who receives assistance. This moves away from the subjective definitions used in earlier policies, where support was often granted based on inconsistent assessments of a person's needs. Certification at this 40% level is the statutory threshold for accessing the Act's specific provisions, including reservations in higher education, land allotment, and government employment. Once that benchmark is established, the Act imposes inescapable obligations on government and private institutions. Section 34 changes government employment from a general diversity goal to a system of strict numerical quotas. Every government establishment must reserve a minimum of 4% of total vacancies for persons with benchmark disabilities. This quota is strictly apportioned into 4 1% slots for blindness, hearing impairment, locomotor disability, and intellectual or multiple disabilities. This apportionment ensures that an establishment cannot fulfill its entire quota by hiring from only one disability category while excluding the others. The same quantitative approach is applied to the physical environment through Sections 44, 45, and 46. Under Section 44, no new structure can receive a completion certificate unless the building plan strictly adheres to the central government's accessibility rules. For existing infrastructure, the Act establishes mandatory timelines. Public buildings providing essential services must be made accessible within 5 years. Service providers face an even shorter window, with a strict 2-year deadline to align facilities with national standards. While the government can grant extensions on a case-by-case basis, the legislation does not allow economic burden to serve as an automatic exemption from requirements. Through 4% quotas and hard 5-year building deadlines, accessibility is transformed from an institutional choice into a rigid operational mandate. These mandates are supported by a punitive legal architecture designed to enforce compliance. Section 84 requires the designation of a special court in every district to ensure the speedy trial of offenses committed under the Act. Oversight is managed by the Chief Commissioner for Persons with Disabilities and their counterparts at the state level, who investigate deprivations of rights. Under Section 77 of the Act, the Chief Commissioner is granted significant quasi-judicial powers to actively conduct these investigations. The Commissioner has the authority of a civil court to summon witnesses, require the production of documents, and requisition public records. Accountability is further extended to the private sector under Section 90, which addresses offenses committed by companies. If an institution violates the Act, the law holds the directors, managers, and secretaries personally liable for the offense. To avoid liability, corporate officers must be able to prove in court that they exercised all due diligence to prevent the commission of the offense. Equipping commissioners with civil court powers and establishing personal liability for leadership changes the risk calculus for both government and private establishments. The RPWD Act of 2016 functions as a highly engineered compliance engine rather than a set of social welfare suggestions. The law constructs a sequence, identifying a medical condition, applying the 40% benchmark, triggering institutional obligations, and monitoring them through special courts. Any failure, like a hiring quota or building deadline, triggers enforcement mechanisms at the pipeline's end. By utilizing the 40% benchmark, the state created a measurable trigger to allocate rights and resources consistently. And by granting commissioners the powers of a civil court, it ensured that those rights cannot be ignored by bureaucracies or corporations without legal consequence. This massive legislative shift originated in Parliament to ground these rights in the physical origin of power. The Act ensures that the transition to an accessible society is no longer a matter of public relations, but a mandatory legal reality.